A quorum being present, the subcommittee will come to order. Good morning and welcome to our guests. We appreciate you being here. We've, I believe, assembled a distinguished panel of witnesses, and thank you all for joining us this morning. Today's hearing is part of an effort that began last Congress to improve the Federal Employees Compensation Act. In 2011, the House passed with strong bipartisan support, and I note that, bipartisan support, a package of reforms that would have strengthened FECA program significantly. Among other provisions, the bill would have improved administrative efficiency, modernized various benefits, and strengthened the overall integrity of the law. While the legislation did not become law, it still represents good public policy and reflects our commitment to addressing this issue in a bipartisan way. We recognize then, as we do now, that the bill passed by the House during the 112th Congress was simply a first step. Without a doubt, more comprehensive changes are needed to ensure the FECA program is meeting the needs of workers and taxpayers. Toward that end, committee leaders asked the Nonpartisan Government Accountability Office to examine proposals put forward by the Department of Labor. I'm pleased to have representatives from both the GAO and the Department with us this morning. The Department's proposal would eliminate increased benefits for those employees with dependents, convert benefits to 50% of gross wages once an individual reaches retirement age, and implement a 3-day waiting period before an individual can draw continuation of pay benefits. These are significant changes to the FECA program, which is why a careful review of the GAO by the GAO was both necessary and appropriate. I will let the qualified experts describe in greater detail the GAO's findings. However, the report does make a couple things clear. First, the Department's proposal would have a disproportionate impact on workers with dependents. Moving toward a single rate of wage loss compensation is worthy of consideration. However, we have to be mindful how this will affect federal employees with families, especially when their colleagues without dependents stand to gain financially. The second point the GAO report makes clear is that there are no easy answers. Fundamentally, we are talking about men and women who suffer an injury or illness while employed by the federal government. But as with any government program, there will be those who try to take advantage of the system. In an article entitled, "Experts Say Fraud Rampant in Federal Worker Disability Programs," the Washington Examiner reveals a program plagued by waste, abuse, and inefficiencies. This is not acceptable, especially at a time when our nation faces a severe debt crisis. Creating a program that prevents abuse by bad actors reflects the realities of the 21st century and provides adequate support to workers will require policymakers to make some tough choices. But we all agree, maintaining the status quo is not an option. We have a responsibility to federal workers and federal taxpayers to create a stronger program, and I look forward to the work that lies ahead. I'm hopeful that in the coming weeks and months we can build on the bipartisan efforts that took place in the last Congress. With that, I will now recognize the senior Democratic member of the subcommittee, Representative Joe Courtney, for his opening remarks.
Thank you, Mr. Walberg. Good morning, and good morning to all the witnesses, and thank you for being here today. And I want to thank you, Mr. Chairman, for calling this hearing to discuss the Federal Employees Compensation Act, or FECA. FECA has been the governing statute providing benefits for federal civilian workers injured or killed on the job since 1916. Not only does it provide compensation for lost wages, medical care, and vocational rehabilitation, but it also ensures that disabled workers are not impoverished while their claims are being processed by continuing their pay for 45 days following an injury. This committee has primary jurisdiction over worker compensation laws and has overseen and repeatedly improved FECA since 1949. At the outset, it is worth noting some of the key principles which underpin this law. First, workers and their families should be no worse off and no better off than if the worker had not been injured or made ill in the course of their federal service. Those who are disabled from their work on behalf of the American people should not be forced to bear any of that cost. Second, since workers surrender their right to bring tort claims against the government for work-related injuries, they need to be fairly compensated in a timely manner with benefits administered in a non-adversarial manner. Civilian workers from all three branches of government are and should be treated equally under FECA, whether they are firefighters, overseas, food inspectors, law enforcement officers, or postal workers. This hearing follows a bipartisan effort by this committee in the last Congress, the 112th Congress, to enact consensus reforms that improved program integrity, modernized benefits that had not been updated since 1949, expanded the availability of medical providers, and provided civilian federal workers who are injured in a zone of armed conflict with an additional 90 days to receive pay while they received a FECA claim. These reforms were reported out of committee in July 2011 as the Federal Workers' Compensation Modernization and Improvement Act, H.R. 2465, and passed the House by voice vote in November of 2011, which is no mean feat in the 112th Congress or the 113th Congress. Regrettably, however, this legislation was not adopted by the Senate. Mr. Chairman, I hope that bill will serve as a foundation on which to build a bipartisan reform effort moving forward. Today's hearing will review the Department of Labor's proposal to, quote, redesign, close quote, benefits under FECA. DOL's proposal reduces the compensation rate for permanently disabled workers at retirement age, reduces benefits for those with families, and lowers the cap on benefits for widows and orphans of federal workers killed on the job. In July 2011, this committee jointly asked the Government Accountability Office to assess whether injured workers in the federal employee retirement system would wind up worse off under the DOL's proposal than if they worked a full career and had never been injured. In late 2012, GAO issued 3 reports covering impacts to federal workers, postal workers, and partially disabled workers. Included in these reports was the finding that cutting FECA benefits for permanently disabled workers at retirement age would leave them with 31% to 35% less than the median benefit package they would have earned if they had never been injured. To date, the Department of Labor has not modified its proposals in response to these GAO reports. I hope today's hearings will explore GAO's findings and help us understand whether we can expect any changes to the Department of Labor's proposal. Again, I want to thank the witnesses for their preparation and extend my appreciation for those who have had to travel a long distance to be with us at this hearing. I yield back the balance of my time.
I thank the gentleman. Pursuant to committee rule, all members will be permitted to submit written statements to be included in the permanent hearing record. And without objection, the hearing record will remain open for 14 days to allow statements, questions for the record, and other extraneous material referenced during the hearing to be submitted in the official hearing record. It's now my pleasure to introduce our distinguished panel of witnesses. Mr. Scott Szymendera is from the Congressional Research Service in Washington, D.C. and is not a stranger to this committee. Mr. Gary Steinberg is the Acting Director of the Office of Workers' Compensation Programs at the U.S. Department of Labor in Washington, D.C. Welcome. Mr. Andrew Sherrill is the Director of Education, Workforce, and Income Security at the U.S. Government Accountability Office in Washington, D.C. And welcome. Dr. Seth Seabury is the longest traveling member of this panel, is an associate professor in the Department of Emergency Medicine at the University of Southern California's Keck School of Medicine in Los Angeles, California. Welcome. Before I recognize each of you to provide your testimony, let me briefly explain our lighting system. Green, yellow, red. You know the rule on that. 5 minutes of your testimony, the yellow comes on with a minute remaining. Seek to wrap it up as quickly as possible, and when the red light comes on, cut it off as quickly as possible. We'll have opportunity to ask questions. The same will be held for our committee members, and we'll have opportunity to ask those 5 minutes of questions. And so now let me recognize Mr. Szymendera for your opening comments.
Thank you. Chairman Walberg, Ranking Member Courtney, and members of the subcommittee, my name is Scott Szymendera, and I am an analyst at the Congressional Research Service. Thank you for inviting CRS to testify before the Subcommittee on Workforce Protections on the Federal Employees Compensation Act, the workers' compensation system for federal employees administered by the Department of Labor. The FECA program began in 1916 and has not been significantly amended since 1974. The testimony of CRS today will focus on two provisions of the Department of Labor's FECA reform proposal: the elimination of augmented compensation for dependents coupled with an increase in the base rate of compensation, and the creation of a lower benefit rate for workers who receive benefits after reaching retirement age. Under current law, the basic benefit rate used to determine the amount of a person's FECA compensation is 2/3 of the worker's pre-disability wage. However, if the worker has any dependent children or a spouse, the worker is eligible for augmented compensation, bringing the total rate of compensation to 75% of the worker's pre-disability wage. The Department of Labor's proposal would eliminate augmented compensation in cases in which a worker has a dependent child or spouse. In addition, the proposal would raise the basic benefit level for all workers, regardless of whether or not they have any dependents or a spouse, to 70% of the worker's pre-disability wage. In the majority of state workers' compensation systems, the basic permanent total disability benefit is 2/3 of a worker's wage at the time of disability. Currently, 38 states and the District of Columbia, as well as the Federal Longshore and Harbor Workers' Compensation Act, have total disability benefit rates that are set at this level. The FECA augmented compensation rate of 75% is higher than that paid by any comparable state workers' compensation system except Texas, which also has a 75% benefit rate. When comparing benefit levels between the FECA program and other workers' compensation programs, it is important to also consider the maximum benefits available to workers. Every workers' compensation system has a limit on the amount of weekly or monthly compensation that any given beneficiary may receive. The maximum FECA benefit is based on 75% of the GS-15 Step 10 pay rate without any locality adjustments, whereas state maximums are generally based on state average wages. Thus, the maximum available benefits under FECA are greater than under any state workers' compensation program or under the Federal Longshore and Harbor Workers' Compensation Act. Under current law, FECA benefits for permanent total disability are payable for the duration of the worker's disability or for his or her lifetime. Benefits under FECA, unlike federal pension benefits, are not subject to taxation. In addition, FECA beneficiaries covered by the Federal Employees Retirement System may not contribute to either Social Security or the Thrift Savings Plan while receiving FECA benefits. Thus, these employees, especially those who were permanently disabled early in their federal careers, may only be entitled to low Social Security benefit amounts and may have low TSP balances to draw from upon retirement. Permanent total disability benefits under FECA have always been payable for the duration of disability or the life of the worker. However, as part of the 1949 FECA amendments, Congress required the FECA program administrator to review the wage earning capacity of all beneficiaries upon reaching age 70 and granted the administrator the authority to reduce a worker's benefits upon reaching age 70 if, in the opinion of the government, the worker's wage earning capacity had been reduced because of age independent of his or her disability. This provision was removed by the 1974 FECA amendments. The Department of Labor's proposal would create a new conversion entitlement benefit for FECA beneficiaries who reach Social Security full retirement age and have received FECA benefits for at least 1 year. The conversion entitlement benefit would be set at 50% of the worker's pre-disability wage and, like all FECA disability benefits, would be exempt from taxation. In 39 states and under the Federal Longshore and Harbor Workers' Compensation Act, workers' compensation benefits for permanent total disabilities are paid for the duration of disability or the life of the worker. Thus, the FECA program is currently in line with the practices of a majority of the workers' compensation systems in the country. In the remainder of the states, benefits terminate after a set duration, when the worker reaches a certain age, or when total benefits paid reach a certain level. North Dakota is the only state that currently converts a worker's benefit to a lower benefit at retirement age. This concludes the testimony of the Congressional Research Service. I will be happy to answer any questions that the subcommittee may have.
Thank you. Mr. Steinberg, recognize you for your 5 minutes.
Thank you, sir. Chairman Walberg, Ranking Member Courtney, and committee members, I appreciate the opportunity to meet with you again to discuss the Federal Employees Compensation Act. On behalf of Acting Secretary Harris, I would like to share a set of balanced proposals that would enhance our ability to assist beneficiaries to return to work, provide a more equitable array of benefits, and generally modernize the program. Almost 97 years ago, Congress enacted FECA to provide workers' compensation coverage to all federal employees and their survivors for disability or death due to a work-related injury. The faces of FECA include the postal worker who is hurt when her mail truck is hit driving and delivering the mail, the FBI agent who is killed in the line of duty, the VA nurse who hurts her back while lifting a patient, and the U.S. Forest Service firefighter who is injured while fighting a wildfire. DOL's Office of Workers' Compensation Programs, OWCP, works hard to administer this non-adversarial program fairly, objectively, and efficiently. We seek to continuously improve quality and service delivery to our customers, enhance internal and external communications, and reduce costs to the taxpayers. This is fundamental to the achievement of our mission to protect the interests of workers who become injured or ill on the job, their families, and their employers by making timely, appropriate, and accurate decisions on claims, providing prompt payment of benefits, and helping injured workers return to gainful employment as early as is feasible. We have made significant strides in disability management that has resulted in significant reduction in the average number of workdays lost from the most serious injuries. Over the last 10 years, the average number of workdays lost due to serious injuries has declined by over 20%, producing an annual savings of $53 million. Our administrative costs are only 5% of the total program costs, far below the average of all state self-insurance programs, which is over 11%. To further improve FECA, we have made a comprehensive set of recommendations to Congress. I wish to highlight some today. To help injured employees return to work, we request authority to start vocational rehabilitation activities without waiting until the injury is deemed permanent in nature, and a mandate to develop a return-to-work plan with claimants early in the rehabilitation process. These proposed changes will also have a positive impact on the government's ability to achieve the President's executive order on hiring individuals with disabilities. We also suggest changes to the benefit structure. For example, the payment of schedule awards for the loss or loss of use of a limb when sight or hearing is often very complicated and thus often delayed. We think that these awards should be paid by DOL concurrently with wage loss compensation, made more rapidly, and to be fair, should be calculated at a uniform level for all federal employees. We also propose to increase benefit levels for burial expenses and facial disfigurement. Under current law, the majority of injured workers receive wage replacement at 75% of their salary, tax-free and COLA'd. This rate is higher than the take-home pay of many federal workers who are working each day, and this can serve as an obstacle to the department's efforts to encourage every worker to overcome their injuries and to go back to work. We therefore recommend shifting the benefit level for all new claimants to 70%. Paying a non-retirement age beneficiaries at a single 70% rate would also simplify the process for both claimants and OWCP by eliminating the continuing need to obtain and validate documentation regarding dependent eligibility. A single rate would be simpler and more equitable and would produce significant savings to the taxpayers. To provide equity to other federal employees, we also recommend establishing a lower conversion rate for beneficiaries beyond Social Security retirement age, which would more closely mirror OPM retirement rates. It should be noted that we recommend these changes be prospective in nature, not retrospective. My written testimony outlines other important provisions that would streamline and improve the program. In summary, while FECA is the model workers' compensation system, it does have limitations that need to be addressed. The reforms that we suggest today are not new. They have been proposed by both current and previous administrations. They are careful, they are balanced, they're well-researched, and they reflect good government while producing a 10-year savings of over $500 million. These changes will bring the program into the 21st century. Thank you again for the opportunity to meet with you today. I will be pleased to answer any questions that you may have.
Thank you. Appreciate it. Mr. Sherrill, we recognize you now for your 5 minutes of testimony.
Chairman Walberg, Ranking Member Courtney, and members of the subcommittee. I'm pleased to be here today to discuss the findings from several of GAO's recently issued reports on the potential effects of proposed changes to benefit levels in the FECA program. Under the current program, total disability beneficiaries with an eligible dependent are compensated at 75% of gross wages at the time of injury, and those without are compensated at 66 2/3%. Benefits are adjusted for inflation and are not taxed nor subject to age restrictions. Some policymakers have raised questions about the level of FECA benefits, especially compared to federal retirement benefits. My testimony today summarizes our findings in 3 areas. First, potential effects of the proposals to compensate total disability FECA beneficiaries at a single rate of either 70% or 66 2/3%. Second, potential effects of the FECA proposal to reduce FECA benefits to 50% of applicable wages at full Social Security retirement age for total disability beneficiaries. And 3, how partial disability beneficiaries might fare under the proposed changes. Our analyses focused on individuals covered under the Federal Employees Retirement System, or FERS, which covered about 85% of the federal workforce in 2009. We conducted simulations comparing FECA benefits to the income, either take-home pay or retirement benefits, that a total disability beneficiary would have had absent an injury. Our methodology matched FECA beneficiaries to uninjured federal workers with similar characteristics, and we use actual data on the uninjured workers' earnings and retirement benefits. In addition, we conducted 7 case studies of partial disability beneficiaries. Our simulations comparing FECA benefits to take-home pay for total disability beneficiaries found that current FECA benefits replaced about 88% of the 2010 take-home pay for Postal Service beneficiaries and about 80% for non-postal beneficiaries. Proposals to set initial FECA benefits at a single compensation rate, regardless of the presence of dependents, would reduce these wage replacement rates by several percentage points. We also found that wage replacement rates under the current FECA program are slightly higher for beneficiaries with dependents, but that under the single rate compensation proposals, they would be higher for beneficiaries without dependents, and the differences would be greater. This reflects the fact that FECA benefits are not taxed, whereas wages are, allowing individuals with dependents to keep a greater portion of their earnings and have greater take-home pay. Our simulations comparing FECA and FERS found that under the current FECA program, the median FECA benefit package is higher than the median 2010 FERS benefit package, and that under the proposed FECA reduction at retirement age, the 2010 packages would be roughly equal. However, the FERS annuitants we analyzed had a median federal career of 16 to 18 years, which is far less than the average of about 30 years under the older civil service retirement system. Recognizing that we had not captured a mature retirement system and had likely understated future benefits of workers with 30-year careers, we simulated a mature FERS system, reflecting future benefits of workers with 30-year careers. This provided us with a basis for assessing the potential benefits of the proposed change on future FECA beneficiaries, which is the focus. We found that in a mature FERS system, the median FECA benefit package under the proposed change would be from 22 to 35% less than the median FERS retirement package. Partial disability beneficiaries are fundamentally different from total disability beneficiaries, as they have received reduced FECA benefits based on a determination of their earning capacity. Our 7 case studies of partial disability beneficiaries show that how they might fare under the proposed FECA changes can vary considerably based on their individual circumstances, such as their earning capacity and actual level of earnings. For example, among our case studies, those beneficiaries with high earnings capacities may elect to retire under FERS and would likely not be affected by the proposed FECA reduction at retirement age because their potential retirement benefits were substantially higher than their current or proposed reduced FECA benefit levels. In contrast, those beneficiaries with low earning capacities had potential retirement benefits that were lower than their current FECA benefits, and the proposed FECA reduction at retirement age would reduce their FECA benefits. In conclusion, FECA continues to play a vital role in providing compensation to federal employees who are unable to work because of injury sustained while performing their federal duties. Our simulations incorporate the kind of approaches used in the literature on assessing benefit adequacy for workers' compensation programs, such as taking account of missed career growth. We assess the proposed changes by simulating the level of take-home pay or retirement benefits FECA beneficiaries would have received if they had not been injured, which provides a realistic basis for assessing how beneficiaries may be affected. However, it's important to note, we did not recommend any particular level of benefit adequacy. As policymakers assess proposed changes to FECA benefit levels, they will implicitly be making decisions about what constitutes an adequate level of FECA benefits before and after they reach retirement age. Thank you very much, and I'd be happy to answer any questions.
Thank you for your testimony. Dr. Seabury, recognize you now for your 5 minutes.
Chairman Walberg, Ranking Member Courtney, and members of the subcommittee, thank you for the opportunity to meet with you today to discuss reforms to the FECA system. My name is Seth Seabury, and I'm an associate professor in the Department of Emergency Medicine in the Leonard D. Schaeffer Center for Health Policy and Economics at the University of Southern California. Throughout my career, I've worked on and led numerous studies of the adequacy of workers' compensation benefits for disabled workers. I'm here today to discuss the potential effects of two proposed changes to the FECA program, the adoption of a single replacement rate for all workers and the proposed reduction in benefits for workers at retirement age. The Labor Department argues that these will help improve return to work and restore equity to the system. However, I have reviewed the GAO analyses of these proposals, and I believe they raise some serious questions about how they would affect disabled workers. First, the GAO analysis shows the proposed shift to a single rate would reduce benefits for most injured workers. Perhaps surprisingly, changing the system to apply the same rate to all workers would actually make benefits less equitable. That is, the effective replacement rate after taxes would be consistently higher for workers with no dependents after the change. An alternative approach could attain a given level of adequacy while making benefits more equitable by targeting post-tax as opposed to pre-tax replacement rates. This could be done by directly targeting replacement rates based on spendable income, as is done in some states, or a simpler change making the replacement rate proportional to the number of dependents. The GAO also found that reducing FECA benefits at retirement age would lower the income for total disability beneficiaries. There is some question over the methods they use because the GAO estimated the long-term impact of an injury on a worker's career growth and future earnings. They did this even though FECA, like other workers' compensation systems, calculates benefits using only pre-injury earnings. But in my opinion, estimating the potential earnings over a worker's career is the only way to get an accurate picture of the economic impact of a disabling injury. Let me explain. Benefit adequacy is measured by how much of the income that someone loses because of an injury is actually replaced by benefits. By definition, how much you lose from an injury is the difference between what you would have made had you not been injured and what you actually did make. For most people, income doesn't stay the same over time. Workers experience employment opportunities that offer higher wages, but these opportunities can be lost or delayed by a disabling injury. Ignoring disruptions like these will provide a potentially misleading account of the true economic impact of an injury. This is important for understanding the generosity of benefits as well as the incentives of workers. Of course, we can't actually observe what someone would have made if they weren't injured. This is something that we have to estimate. The GAO analyses compared what FECA beneficiaries actually made to the earnings of uninjured workers who were otherwise similar. That is, they had the same age, had a similar job, etc. This approach has been widely used by myself and others to evaluate workers' compensation policy in state systems, and the National Academy of Social Insurance declared it the preferred approach for assessing the adequacy of disability benefits. Applying these methods, the GAO found that the loss in career growth and retirement savings meant the retirement age FECA beneficiaries had benefits that were comparable to or lower than what they would have received from the federal employee retirement system if they worked a full career without getting injured. This means that reducing FECA benefits at retirement age could significantly reduce retirement income for most of these beneficiaries. However, it is true that some workers might earn more under FECA, but more analysis could be done to identify which workers would benefit more and design a more targeted response. These changes have been proposed, at least in part, to improve return to work for disabled workers. It is true that if reducing benefits motivate return to work, we would expect the additional income from working to offset the lower benefits. Improving return to work is a vital policy goal. But it is unclear whether or by how much these benefit changes that are proposed would actually lead to improvements in return to work. The current system already reduces benefits for workers who are deemed to have recovered to the point that they have some capacity for work. If this reduction is insufficient to cause them to work, it is unclear how much additional effect reducing their benefits at retirement age would have. In general, more evidence is needed on this issue, and more evidence is needed on the adequacy of FECA benefits for partially disabled workers. This concludes my testimony. I'd be happy to answer any questions.
Thank you, and I thank each of the panel members for your testimony. I recognize myself for 5 minutes of questioning. And Mr. Steinberg, I want to start with you and ask you to directly respond to GAO's findings and to elaborate on the basis for the Department's proposals, specifically with respect to the proposal to set a uniform benefit rate. Do you have any concerns with maintaining a level of equity between individuals with and without dependents? And with respect to the proposal to reduce benefits at retirement age, do you have any concerns with the adequacy of benefits at retirement age for an individual who experiences an injury early in his or her career?
Thank you.
Your microphone.
Thank you. We respect the work that's done by our colleagues in GAO. Over the last decade, we have worked closely with them to analyze this particular issue. We note that their report predominantly focuses on wage replacement rate, but it doesn't address the comprehensive package that has been proposed. And the reality is, from our perspective, that each of the components need to be reviewed and they need to be looked at in a balanced way. The wage loss change, the reductions are only one dimension. There are other dimensions which actually enhance the situation for a beneficiary. With respect to the study, as my colleague indicated, they provided no consensus on appropriate rates, nor did they provide specific recommendations. They didn't suggest that the 70% rate was inappropriate. They suggested that there are different options, and we agree that there certainly can be different options, but based on our analysis, we believe that 70% is a proper rate. They failed to address the issue of return to work and the implications that return to work can have, both in terms of the liability to the organizations as well as to the individual. Lastly, they did not address the issue of the schedule award. And the schedule award is part of our balanced proposal that provides compensation for those individuals that have a permanent loss of functionality. That should be viewed as part of the comprehensive package. It's an investment once received that the individual can use to prepare for their future. And the study does not reflect that. The study does acknowledge the fact that the reduction at retirement level will bring the level closer to the FERS level. Let me talk now a little bit about our process. We have consulted extensively with OPM, with GAO, with the IG community, with our partner agencies. We have looked closely at the states as well. I think, as you have heard from all the panel members, the FECA program is the most generous of all. And as Dr. Seabury indicated, even with the changes that we propose, our rates will still be more generous than any of the state programs. The 70% level reflects a midpoint between the 66 and 2/3 and the 75%. Even at 70%, it will be greater than the vast majority of the states. And we believe that it's fair, and we do not believe that it's going to harm any of the claimants. With respect to the retirement level, we consulted extensively with OPM. We studied the CSRS program. We also studied the FERS program, which is coming to a level of maturity. And based on our analysis, OPM confirmed the fact that the 50% tax-free level that we propose equates to the levels for CSRS. And they indicated that they have designed FERS, which is a more complicated program, to roughly come to the same level as CSRS.
In respect to time, let me move on. Mr. Seabury, your testimony discusses the techniques GAO used to estimate the missed future earnings of FECA beneficiaries. However, as GAO notes in its report, FECA was not designed to account for missed career growth. Your testimony also notes that inherent unknowability is predicting an individual's actual future career path. So in your opinion, how should policymakers approach GAO's findings, given FECA's benefits were not designed to increase at a rate comparable to career growth?
So FECA, like other workers' compensation benefits, are not designed to incorporate, they're not designed to reflect career growth in the benefit levels. However, I don't think that means that we shouldn't consider that career growth when evaluating the impact of the policy on workers. This is true for considering the adequacy of benefits, but also for understanding workers' incentives. if I have the capacity to work but choose not to, I'm missing out on that potential career growth. So not only by not focusing on a career growth, not only am I making potentially benefits look more adequate than they actually are, I'm also potentially making the incentive problem look worse than it actually is. So I think that we need to incorporate these estimates of career growth in order to best understand how the system's affecting workers on many dimensions.
Well, thank you. My time has expired. I recognize my friend, the ranking member, Mr. Courtney.
Thank you, Mr. Chairman. And Mr. Sherrill, again, listening to Mr. Steinberg a few minutes ago, who talked about the way DOL tried to consult with all the different agencies, OPM, GAO, CRS, et cetera, in terms of this retirement proposal that they've come forward with. Again, maybe they consulted with you or reviewed your report, but again, looking at your report, when I read it, it certainly, seemed to suggest that in many instances, disabled workers would clearly be worse off with the, the proposal to reduce benefits at retirement age than if they had worked 30 years and retired under FERS. And again, it appears that their core objection is that GAO should not have accounted for the lost career growth in its comparison because workers' compensation benefits are not adjusted to account for lost promotional opportunities. So I just want to run through a couple questions with you, if I could. Okay. First, what is the relevance of accounting for lost career growth, and what is your response to DOL's position?
Well, it's important to account for it's important to account for missed career growth in doing these kinds of benefit adequacy studies because that provides the most realistic assessment and readily understandable assessment of how people would fare under the program compared to where they would have what they would have had in the absence of an injury. This is the kind of approach that's commonly used in the literature to do that, to do these kind of benefit adequacy studies.
And that's the approach that you took?
That's the approach that we took.
And is your approach consistent with OPM in terms of what they recommend in terms of how to analyze this?
When OPM did briefing slides on these proposed changes, one of the things they reiterated was that in considering changes at retirement age, it's important to look at that in the context of what workers would have had if had they not been injured, what their retirement package would have done. That's consistent with what we did.
Okay, and in terms of outside, credible, neutral sources, is the methodology that you used to follow the recommendation of the National Academy of Social Insurance?
Yes, we're consistent with the matching methodology, taking missed income career growth that they recommend.
And in fact, DOL had previously argued that GAO needed to account for lost promotional opportunities when evaluating the adequacy of FECA benefits. Is that also correct in the past?
That's right. We had done a 1998 report on FECA looking at wage replacement rates where we had not factored it in because of limited data at that time. Labor in its comments took issue with that and said that the wage replacement rates would have been higher if we'd factor in missed promotions.
So do you have any explanation for why the department has changed its views?
I wouldn't speculate on that.
Okay. Mr. Steinberg, maybe you can help us then answer that question. It's just, obviously, what we just heard was that some of these other sources that you say the department consulted with clearly have a different approach than what you described this morning.
I can't speak to the position 15 years ago. Well, what I can comment on is that in the GAO report that Mr. Sherrill referenced, GAO indicated that they did not believe that promotional career growth should be calculated in because it was speculative in nature and therefore extremely difficult to predict what the growth of an individual would be. We have looked at all federal workers' compensation programs for which I oversee. We also looked at all of the state programs. None of the state programs nor the federal programs reflect a career growth potential. From an academic perspective, it's certainly something that can be looked at, but we don't believe that it should be, nor has it ever been, part of the compensation package for a workers' comp program. If you look at it from a practical perspective, it's very difficult to predict what the career path of an individual would be. One person may be a superstar, we don't know that. One person may be very satisfied working at a GS7 level and not anticipate any career growth. Lastly, there may be an individual who's on a performance plan and is likely going to be removed from their position. Now calculating a career potential, we believe, would be speculative and inappropriate.
Well, except, I mean, FECA, under its present design, is not, I mean, no one's like using a, you know, inventor of Google kind of career path. I mean, this is still a very, you know, modest system that is in place right now. So, you know, I mean, looking at it from a real practical standpoint, to use your own language, I mean, we heard earlier that, you know, somebody who's disabled at a relatively young age, you know, that FBI worker or that firefighter that you described, you know, who's not paying into Social Security, I mean, their benefit level at age 65 is going to be, you know, definitely suppressed as a result of that life-changing event. So from their practical standpoint, you know, converting the system to what you're proposing, I mean, really has a very negative impact, and again, really kind of takes away what, on balance, most workers can expect to have at least some step up over time, particularly when it's at a young age, when the disability occurs.
I would respond to that in two ways. One, we have a COLA. The reality is, for the last 3 years, working federal employees have not received the cost of living increase, yet the individuals on workers' comp have received an increase. And we think that's extremely important, and that obviously should continue. Never has there been a factor for career growth, again, because we can't anticipate that. I think to look at it from the converse, our goal is to get people back to work just as quickly as we can. We work to get early diagnosis, early treatment, early rehabilitation, and then help them find the right job. What we have found in talking with the IG and talking with other partner agencies is that the increased level of the benefit at 75%, as well as if there was to be included a career growth factor, then that would be a disincentive for people going through the activities of getting healthy and going back to work. And I think we want to avoid any disincentives.
The gentleman's time has expired, and now I recognize Dr. DeJarlais for your 5 minutes.
Thank you, Mr. Chairman. Thank you all for appearing today. Dr. Seabury, we'll start with you first. Your testimony notes that one way to make benefits more equitable between beneficiaries with and without dependents could be to target wage replacement rates on spendable or after-tax income as opposed to pre-tax gross wages as is used in the FECA program. First, can you explain how this target would work in practice, and then can you also elaborate on the potential benefits and costs of this approach?
Well, I think there are different ways you could try to accomplish this in practice, and I would want to refer to some of the actual details of the state systems to give you the details on how you would actually implement a system. But the idea is to focus on, rather than looking at the share of your pre-tax, pre-injury earnings that is replaced, they target 2/3 of that. Some states have focused on, say, 80% of spendable income. So they try to evaluate your spendable income in the pre-injury period and set a varying benefit level so to target the after-tax replacement rate. I think in terms of the costs and benefits, that could be potentially a more difficult system to administer. So I think that would be one of the more probably the potential cost. The benefit would be increased equity. I think one of the things that was actually somewhat surprising to me and very interesting to me about the GAO's reports was showing how a single pre-tax replacement rate creates this inherent inequity in the system between workers with and without dependents, or reverses the existing one and exacerbates it. So I thought that was interesting, and so you would be able to avoid that kind of inequity with focusing on after-tax replacement rates. I do think, you know, there are ways to try and implement a system and make it simpler to administer while still trying to attain those benefits.
Okay, thank you. Mr. Steinberg, I noted in your testimony it stresses that the entirety of your reform proposal is intended to improve the FECA program. Of course, the majority of the focus of today's hearing is on the two major benefit proposals. Are there any other proposals we should be considering that are intended to work with the two benefit proposals or are closely related to those proposals in serving to improve the FECA program? Could you turn your microphone on?
That's twice now. I apologize. This proposal has been fairly stable over the last several years. As I indicated in my testimony, it has been provided by previous administrations and this administration. The general components of the proposal, which I've described as comprehensive, broad in nature, yet not sweeping in change, has been consistent. And again, it's addressing multiple dimensions of improving return to work, providing an increased level of equity, and streamlining and modernizing the program, sir.
Okay, thank you. Mr. Szymendera, your testimony notes that additional or augmented benefits for workers with dependents was added to FECA in the 1940s. At that time, some 10 states also provided for a type of augmented compensation. However, your testimony further notes that today no state provides augmented compensation for dependents. Can you discuss the move away from augmented compensation for dependents at the state level?
Well, to be honest, CRS has not looked so much at the history of state developments as much as we've looked at the history of the FECA program. It was noted that, interestingly, in 1949, when they added the augmented compensation, one of the reasons they said they were doing it was to be consistent with the states, and so we went back to the laws in place in 1949 and found only 10 states, and none today. As to why states have moved away from that, I don't know. One of the things that has been cited by the Department of Labor, both here and in other forums, is augmenting compensation for dependents can be difficult because they're changing when a child reaches 18, no longer a dependent. There are some provisions if the child is permanently disabled, him or herself. So there are some administrative difficulties that may be present there. But that would be, with absent any research into why those specific states moved away, it would really be speculation.
All right, thank you. And Mr. Sherrill, I did have a question for you, but my time is about to expire, so I'm sure we'll get to you. Thank you. I'll yield back.
I thank the gentleman. I recognize the gentleman from California, Mr. Miller.
Thank you, Mr. Chairman, and thank you very much for holding this hearing. Dr. Seabury, DOL seems to be making an argument that somehow there is a sort of a significant disincentive to return to work when you compare FECA benefits with the OPM data. Do you see this, or is there, what other evidence is there to suggest that that's either the case or it isn't the case?
Well, it is true that FECA benefits are, in general, more generous than state systems, as we've heard. So, and there is evidence out there that increasing benefits can have a modest effect on return to work incentives.
Do we see these people not returning to work at a very different rate than state programs? Or
actually, I haven't seen a direct comparison. My impression is that return to work in the FECA program actually seems reasonably good, but I'd have to see some more empirical evidence on that.
Has either Labor or GAO looked at this? Has Labor looked at this?
Oh.
Again, our findings are from observations from our claims examiners, observations from the IG community that we work with, and other partner agencies who share with us that they do have problems. And again, we don't think that this is a rampant issue. There are some people within the community.
Well, if it's rampant, I assume we'd be all holding a different hearing at the moment. I want to know if it's enough evidence to base it upon the conclusions that you arrived at as to that somehow this benefit would drive people not to return to work.
Yes, again, what we have seen is that with the benefit being higher at 75% and remaining that level at retirement age, we believe that that's a disincentive to people going back to work.
You believe that? That's what I'm trying to find out, how you base that belief.
Again, that's from discussions that we have had with our partner agencies, with the IG community that has investigated particular cases and have discovered that an individual will, if you will not participate in a vocational rehabilitation program and will find other reasons to stay on the workers' comp program because it is very generous. So to suggest that we have empirical analysis of that.
So this is an element of human nature that just expresses itself when you're injured.
Yes, sir.
And so what, if you take away support for their dependents and you lower the overall benefit, that you'll drive them to work?
Well, again, the proposal to reduce the benefit is twofold. One is a matter of equity, that in many situations we have individuals who are on workers' comp who are receiving more than their colleagues who are working. And then the second factor is the disincentive, the fact that there are certain situations where an individual would rather stay at 75% tax-free than to go back to work. So we believe that both the matter of equity and fairness
Well, let's talk about the people that decide that's not the case, and they need the 75% to provide the wherewithal for their families.
Well, again, we believe that, and as GAO has concluded, the change from 75% to 70% will have fairly limited impact on the majority of individuals. The study fails to reflect the fact that many are dual income families, then the fact that the individual is out of work but yet still receiving, in this case, a 70% benefit is still sufficient. And again, it's still more than their colleagues in the
Why would we give anything to people who are dual families if their spouses are making a lot of money? And we say, well, that's good enough. You don't get anything.
Again, we don't factor those types of things into.
But you just did.
I'm sorry?
You just did. You make an assumption about some are dual workers, so this really won't harm them. They don't need this. Well, let's assume the spouse is making $1 million a year. This is about the injured worker, isn't it?
This is about the injured worker, but it's also about the ability of the injured worker to obviously...
Do we have an incomes test then, a family income test?
To have wage replacement that is reflective of what their salary was.
Do we have an incomes test?
Do they have
so we know how well the spouse is doing, so maybe we can pay them less?
We don't do that analysis, sir.
But yes, you did. You did it when you decided you're going from 75 to 70%, because in some cases people won't go back to work, and one of the reasons they might not go back to work is they're in a dual-income family.
No, I'm not.
Does it make a difference if they're in a low-income dual-income family or a high-income dual-income
No,
family?
I'm not suggesting that that's the reason for the reduction in the rate, sir. I'm saying that that's now the work environment. When these rates
let's go back and we'll read the testimony, because I think you did suggest that that's the reason.
I'm sorry?
I said we'll go back and read the testimony, because I think we'll see that you did suggest that that's the reason. I'm just trying to find out what's based on fact and what's based upon assumptions, and how we disallow or allow based upon those assumptions.
Well, again, two points. One, the based on fact is the matter of equity with individuals who are working who are not injured, and a matter of going from 75% to 70% is a matter of fact and a matter of equity. And that has been studied. The issue of the disincentive, as you indicated, sir, is human nature, but it's something that we have observed, and our partner agencies have observed the fact that people are more comfortable staying at that rate. The IG community has observed that as well, sir.
I think most states suggest the American worker is driven to go to work. Kind of opposite in most other countries, but anyway.
The gentleman's time has expired, I'm afraid, and now I recognize the distinguished chairman of the Education and Workforce Committee, Mr. Klein.
Thank you, Mr. Chairman, for the hearing. Thank the witnesses for attending. As you can tell, there's some considerable interest here in this committee on this issue. As the Chairman Walberg pointed out, we passed some legislation out of this committee in the House in the last Congress to address some of these issues, and we called for the report, the GAO report, and the input from the distinguished folks on this panel as we move forward. There are other committees, certainly in Congress and the House, that are looking at this issue, sometimes in connection with other departments, Postal Service and so forth. So it is an issue that has to be addressed, and we need to understand it. And so I'm very grateful for all of you here in your testimony and the work you've done in the research and in your reports as well as your testimony. Mr. Szymendera, your testimony, and again, thank you for your work for CRS and GAO. We depend very heavily on the work that you guys do, so thank you for that. But your testimony notes the choice FECA beneficiaries can make at retirement age to remain on FECA or leave the FECA program and receive federal retirement benefits. What other benefits could a FECA beneficiary be eligible for? For example, FERS disability, retirement, Social Security disability, and what issues should be considered in terms of how FECA benefits can coordinate with, mesh with these other benefits?
Well, there are several benefits that a FECA beneficiary could be eligible for. You mentioned Social Security disability benefits. There is if a any workers' comp beneficiary, whether they're FECA or an estate workers' comp, is also eligible for Social Security disability, their combined FECA benefit plus the Social Security disability benefit cannot exceed 80% of their pre-disability wage. And that's the same for state workers' comp beneficiaries as well. There's an offset mandatory in the Social Security Act for people who receive both workers' compensation and Social Security disability insurance. Once a FECA beneficiary reaches retirement age and they have to make this election, do I stay on FECA or do I go to FERS or CSRS or another? As you know, there are other smaller federal employee retirement systems as well. There's also to be considered the possibility of what is going to be their level of Social Security retirement benefits. As you know, under the FERS system, when Congress created the FERS system, when they moved away from CSRS, Social Security is a key component of that system, as is the thrift savings plan. And so I think when employees make that decision, they have to look at how much their FERS annuity would be, how much they intend to receive from Social Security, which they should be somewhat aware of with information from the Social Security Administration that Congress requires them to provide, and then, of course, how much is in their TSP account, and that would play a role. If they go to retirement age and they're at the very, very low end because of all that income, then you're looking at a program like Supplemental Security Income, SSI, which is administered by the Social Security Administration, which could then provide an additional benefit, an income benefit to them as well. So there are, and then of course in other cases, as the Department of Labor has mentioned multiple times, for example, FBI agent or federal firefighters, they're eligible for public safety officer benefits, which I believe is over $250,000 lump sum from the Department of Justice. That's in addition. Several agencies, such as the State Department, have annuities for employees killed overseas. That gets added to that as well. So it can get a little bit complicated depending on the circumstances of the individual employee.
Thank you. I would say it's not that it can get complicated. It just got complicated in listening to that. I was going to ask for some comment from Dr. Seabury as well, but I see on the same subject, but I see the light is rapidly moving towards red. So thank you very much again to all the panelists for your testimony and for your participation, and I yield back the balance of my time.
I thank the gentleman, and I now recognize Mr. Hudson for your 5 minutes of questioning.
Thank you, Mr. Chairman, and thank the panel for your testimony today. I'd like to start with Mr. Szymendera. Could you briefly discuss the policy considerations surrounding the treatment of benefits before and after retirement age? Specifically, what considerations may account for a workers' compensation system that continues benefits past retirement age? What policy rationale may account for different treatment of benefits at retirement age?
I think it ultimately really is a fundamental question of workers' compensation that goes back, in the case of FECA, to the beginning of the program in 1916 and the beginning of workers' compensation in the years before that, and that is, what is the role of workers' compensation? Is it simply year-to-year wage loss? If that is the argument, that all workers' compensation is supposed to do is replace year-to-year wages, then I think a logical argument can be made that when a person reaches a certain age, retirement age, there's no wages to replace. They wouldn't be working otherwise. Now, that age differs for different people. People retire different. But Congress could set an age, as they have set a full retirement age for Social Security. If you argue, that's one argument. If you argue that no, workers' compensation is more than that, it is intended to provide a benefit to a worker who was hurt at work, under the assumption that the employer has a responsibility to provide a safe workplace, which Congress established in 1970 with the Occupational Safety and Health Act, for example. And this person went to work and got hurt. Irregardless of fault, it's the employer's responsibility. And there are all sorts of costs involved in becoming permanently disabled, not only lost wages, but other costs. If you say that the goal then of FECA is to replace as much as possible all of those costs, and provide for that worker, who, remember, cannot sue the employer. And if they sue a third party, has to essentially give back under the subrogation rules that money to FECA. Then I think it becomes harder to make the argument logically that benefits should be cut off at a certain point, because a person remains permanently disabled into their 60s, 70s, 80s, however long. They've lost lifetime earning capacity, and they may have incurred other costs that are associated with disability, not to mention other things that would be compensated in the tort system, such as pain and suffering. Remember, as Department of Labor mentioned the postal worker in the car accident. The postal worker in the car accident is limited under FECA to what he or she can receive, different than the private citizen in the car accident, who may well, under a tort claim, receive money for pain and suffering, punitive damages against the offending party that would be paid. None of that is available under workers' compensation. And so if you feel workers' compensation is more than just year-to-year wage loss, then I think it becomes more difficult logically to justify a cutoff at a certain age. This is a debate that really goes back to the beginning of workers' compensation, and it's a debate that Congress took up in 1949 when they decided to implement a mandatory review at 70. They didn't cut off benefits at 70, but they implemented mandatory review. And it's a debate that Congress revisited in 1974 when they rescinded the mandatory review. These same arguments that I've just made and many of the same issues we're discussing today were discussed in, if you look at the hearing record, in 1949 and in 1974, and of course in recent Congresses. And so it's really comes down to what Congress wants as the fundamental goals of this program. And I think that ultimately would guide where the policy would go in regards to benefits after retirement age.
Thank you for that. Mr. Steinberg, just to clarify for the record, is DOL intending to incorporate any of the GAO findings into its proposals?
We don't have a timeline. I'm sorry, sir. We don't have a timeline for submitting a legislative proposal. However, in terms of the findings of the GAO study, we do not believe that we should change the proposal that we have. To build on my colleague's points, again, I think the difference between our program and most of the state's programs is that this is a lifelong benefit as long as the individual still has that work-related injury or illness. There is no cap, either from a time dimension or from a dollars and cents perspective. We believe that it's our obligation to protect the federal worker. So there are no changes that we propose as a result of the study by GAO.
Okay, thank you for that. And I'm interested in this discussion we've had sort of over the incentive to return to work. So I'd like to maybe discuss with you briefly here how the FECA program is working to reduce injured employees' time away from work and return employees to work. Can you explain in some detail the program's goals? And
the gentleman's time has expired.
I'll submit that in writing. Thank you.
Thank you. I now recognize the gentleman from Indiana, Mr. Rakita.
Well, I thank the chairman and I thank the witnesses for your testimony today. Mr. Steinberg, could you answer the congressman's question?
I can, and I can proudly answer that. We have extensive focus on return to work. I think in years past, workers' compensation programs were typically seen as a wage loss replacement program. And yes, our program does provide that, and it's a hallmark of our program to have a very generous level. But we spend a significant amount of time focusing on return to work. We put in place a disability management program where we have staff nurses that work with field nurses. We try to get to the claimant as early as we can to make sure that they get diagnosed, they get into early treatment, and they get into early rehabilitation. Those are some of the proposals that I talked about in my testimony, to permit us to engage in vocational rehabilitation before the injury is identified as permanent in nature, which is typically 6 months. We believe that if we can begin vocational rehabilitation and put in place a rehabilitation return to work plan earlier in the process, we have a much higher probability of returning the individual to work. Our statistics are terrific. 85% of those individuals with serious injuries that are out of work for more than 45 days, 85% go back to work within 1 year, and 92% go back within 2 years. Of the approximately 120,000 cases we receive each year, Only about 2,000 of them go on our periodic rolls at the end of the 2-year period. And I think to a large extent that's because of our interventions.
Thank you, Mr. Steinberg. I also witnessed the spirited exchange that Congressman Miller had with you. Do you have anything to add to that?
Well, again, I think it's important to point out that OWCP, the Department of Labor, we take terribly seriously our responsibility to protect injured workers. I think this is being, unfortunately, portrayed as an intent to harm federal employees, and that certainly is not the intent. What we have done is analysis of the rates that we have and the rates that the states have. We've also talked with OPM in terms of what retirement rates should be, and we believe that we have proposed a slight reduction in rates, not major changes, but a slight reduction in rates that provide a level of fairness and equity between the injured worker and the non-injured worker.
Okay, thank you, Mr. Steinberg. And Mr. Sherrill, am I pronouncing that right? Thank you. Quick question for you, maybe not so quick. Your testimony notes that in the prior report from 1998,
yes,
GAO analyzed the adequacy of the FECA benefits by comparing benefits to take-home pay at the time of injury.
Yes.
The current report compares benefits to take-home pay an employee would have had absent an injury.
That's right.
First, can you briefly elaborate on the different methodology used in each report? And then also, as we consider policies in this area, what do you think are the merits and drawbacks of each methodology?
The 1998 report basically answered the question of to what extent do the FECA benefits support the person in maintaining the standard of living they would have had at the point of injury. And so it factored in wage increases, sort of average wage increases for the federal workforce over time. That factored that into the analysis. The work that we've done here with improved methods, access to the additional data sources, factored in what would the person's missed career growth have been, because we matched them to a very closely matched counterpart. And so it really gave a sense of, how adequate are the FECA benefits with respect to what they would have otherwise received in terms of federal wages and salary.
So an improvement, this later methodology over the earlier one.
Yeah, because in the past, it was the data often were not available to really get a sense of how people would really be affected and to assess the counterfactual in the absence of being injured, what would have been the case. But now we have better data, better methods to do that kind of analysis.
Thank you. And the last two witnesses, while I have some time, Dr. Seabury, anything to add along the lines of the questions that I asked? In 30 seconds.
Yeah, 30 seconds. I just would like to confirm, I do think that the approach to using the matching approach is an improvement. I think that a distinction needs to be made between what's used to calculate benefits versus assessing the effect of a policy change on workers. And so I think to capture the actual effect of the policy change on workers, you need to consider the lost career growth, because that's a very real consequence of a workplace injury that should be factored in. And with return to work, I think the real challenge with return to work is there's an assumption that, it's an unknown how much of the workers who are on long-term disability currently have the capacity to work but aren't choosing to because of financial incentives. And I think it's just not clear, there's not enough evidence to say how big a share that is. And so I think the biggest concern with some of the policy proposals is that the DOL proposals to get people back to work are great, including increased rehabilitation, but we don't know how that's going to affect the people who don't get back after those policy changes are in place.
Apologies to Mr. Szymendera. My time's expired.
I thank the gentleman, and I recognize the gentlelady from Oregon, Ms. Bonamici.
Thank you very much, Mr. Chairman. I apologize for not being here for the testimony, but I did review it in advance. I was in a committee markup. I want to thank the chairman and the ranking member for putting together this bipartisan hearing on such an important topic. Our public servants are great assets to our country and deserve a workers' compensation program that ensures that they're no better off than if they hadn't been injured or made ill on the job. Mr. Steinberg, I'm sure you're aware that bills have been proposed in the House to reform the Postal Service, and at least one of those includes a provision that would take postal workers out of FECA and instead have the Postal Service administrator administer its own program. On top of that, it would force workers above retirement age into retirement benefits rather than keeping them in FECA. So this proposal is concerning to me, among others. What is the administration's position on removing Postal Service workers from FECA?
Well, the administration's proposal does not propose a separate system for postal employees, but recommends system-wide reforms for all federal employees. We believe that the proposals that we will put forward will benefit all agencies. I'll point out that the Postal Service is about 45% of our customer base, so obviously they will benefit from the changes that we're putting forward. The President's budget does not either put forward a proposal to separate the workers' comp program and put it with the Postal Service. We believe that creating a separate system would be extremely complex, it would be extremely expensive, it would be very labor-intensive, it would require a substantial and entirely new infrastructure to be established by the Postal Service. Much of the work would likely be contracted out as opposed to being performed by federal employees as it currently is today. We think it will be significantly more expensive. As I indicated in my testimony, our administrative costs are 5% of the program. The best of the state programs is at about 11%. That's the average. And we would project that the cost of the Postal Service doing this would be at least double the administrative cost for us doing that. Another concern would be that establishing a separate system could raise equity issues if benefit levels were different or if their processes were different. Again, we believe that our proposal will have a positive impact on the Postal Service, and I believe the administration believes that this is how we should move forward.
So I can infer then that the administration opposes a separate system.
The administration has not proposed a separate system.
No, that they oppose a separate system for postal workers.
Again, the administration has not specifically addressed this. This is something new that has been discussed. I have not had conversations with the administration specifically on that. What I can say is that the administration supports these changes and believes that these changes are the right way to move forward and will benefit the Postal Service. And
you mentioned states. I know benefits vary from state to state. Oregon, for example, provides permanent disability for life at maximum of $1,064 per week. But is FECA generally consistent with the majority of states with regard to maintaining permanent disability benefits through retirement age without a reduction? How many other programs provide benefits without reduction past retirement?
I'm sorry, could you repeat the latter part of the question?
Yes. How many other programs provide benefits without reduction past retirement age?
Again, we're not... Many of the programs are actually capped in terms of time and then capped in terms of dollars. We tend to be the only program that continues on for the life of the individual. So I can't provide that comparison right now.
Thank you. I'll follow up. And I have a question for Mr. I hope I say your name right. Szymendera? Was I close?
Yes, Szymendera, yes.
Szymendera. Your testimony notes that FECA beneficiaries covered by the Federal Employees Retirement System may not contribute to either Social Security or the Thrift Savings Plan while receiving FECA benefits. As a result, employees, especially those who are permanently disabled early in their careers, may end up with smaller Social Security benefits and low TSP balances on retirement. So what are the implications of putting into place a general age-based test for FECA benefits? Would this be inconsistent with the purpose of a compensation law that's designed to make workers whole if they're permanently disabled?
Thank you. First, if you don't mind, I can address that first question you asked the Department of Labor, and that is currently 39 states pay benefits for the duration of disability or the life of the worker, as does FECA, as does the Federal Longshore and Harbor Workers Compensation Act. One additional state pays only in catastrophic. So, some of the state laws can get very complicated, but the general rule, the general answer would be 39 states.
Thank you very much.
So FECA is consistent with the majority. Now, as to your question, and I think it is, as I mentioned before, it gets to this idea of what is the overall intent of the program. FECA, FERS relies on three components. Two of those components are Social Security and TSP. If you have a worker injured, especially at a young age, they're not going to be able to build up the balance in TSP, possibly, or have the Social Security to rely on, and so they're really going to rely primarily only on the FERS annuity. It gets ultimately to what is the goal of the program. If it's just year-to-year wage loss, then you say, well, a person at retirement age wouldn't be working anyway. If it's we're trying to make this worker to some degree whole because of an injury that occurred in the workplace, and we believe the employer, in this case the federal government, has a responsibility to do that, then I think you do have to consider the fact that you may have a worker with 2 of the 3 components of the retirement system that may be very low TSP balance and a low amount from Social Security.
Thank you very much. I see my time has expired. Thank you, Mr. Chairman.
Thank the gentlelady. And again, thank you to the panel for your answers, for your experience, and what you shared with us today. I now recognize the ranking member for closing comments.
Thank you, Mr. Chairman, and the panel. This is excellent testimony, and I think is going to give us a great record as we move forward, considering, again, the possibility of a bill that hopefully will be as bipartisan and as successful in the House as last year. And I really want to, again, salute Mr. Szymendera for the great historical perspective that you added to this hearing. You know, it is important, I think, to remember that worker compensation law, which, you know, a first-year law student is instructed, was set up, and it was a trade-off. People gave up their right to access the civil justice system, which provides, again, a much broader array of benefits than what, again, the firefighter or the FBI agent who's injured on duty can collect. And that's why, frankly, you know, looking at the administration's proposal, which, again, I think only North Dakota is the only state that was cited in the CRS report that converts the benefit at retirement age, in my opinion, would put the system, you know, as an outlier, to say the least. I mean, Connecticut, I'll toot my own horn here, allows for, again, a benefit that extends beyond retirement and no conversion in terms of the calculation of the benefit. And to me, that's consistent with that trade-off. So, again, this hearing, I think, is going to help us really understand better the implications of the proposal that the Department has come forward with. GAO has informed us that DOL's proposal to cut benefits at retirement age for totally disabled workers will leave the median worker in the FERS system, in many instances, worse off than if they had worked a full career and not been injured. This finding applies to both executive branch workers as well as postal workers. GAO's findings raise troubling concerns about the merits of DOL's proposal as it violates a basic principle underpinning FECA, which is to ensure that workers are made whole if they are injured on the job. The bottom line is no one should be better off or worse off than if they had not been injured. And this applies to federal law enforcement injured in the line of duty, firefighters protecting life and property, prison guards keeping our community safer, letter carriers injured in an accident. And as a matter of equity and the interests of avoiding more bureaucracy, it makes little sense to remove postal workers or any other group from FECA and create a separate program, which, again, I think hopefully is a consensus point here this morning. We have learned from our witnesses that GAO uses a mainstream approach in assessing benefit adequacy. In response to GAO's findings, I would urge the Department of Labor to reevaluate its proposal. I'm aware that some are advocating approaches that would jettison core principles underpinning FECA and simply cut without regards to the impact on disabled workers who must rely on FECA as their exclusive remedy. Therefore, and I think hopefully all of us agree, our approach to reform should always be data-driven. With the additional GAO data in hand, I hope that we can continue our bipartisan efforts that were launched in the last 112th Congress. That includes giving DOL tools to better improve program integrity, increasing the number of workers who will be rehabilitated and resume work at the federal agencies, to modernize obsolete benefits and increase the cost effectiveness of medical delivery by utilizing physician assistants and nurse practitioners to deliver treatment. Mr. Chairman, in closing, I would move that the committee include a statement from the National Treasury Employees Union and 3 other documents regarding GAO's assessment of the DOL proposal be placed in the record. And again, I want to thank you for organizing this outstanding hearing, and I yield back the balance of my time.
Thank the gentleman. Without objection, those will be placed in the record. I would concur with your statements to a great degree as well. I think the fact that we passed in the last Congress a bipartisan proposal and did it on voice vote out of the chamber was significant, and I think it was significant for many reasons, but because it provided some updating to a law that we felt was necessary and we could agree to. We certainly want our federal employees to be cared for. We certainly respect what they do, and when injured in the line of duty, we're responsible for providing care. Just to make sure that that care is adequate, that it doesn't give unnecessary incentive or additional incentive to bad actors, but also recognize that the overwhelming majority of our workforce who are injured have legitimate needs, and that those needs are met. The provisions that we did not include in the last bill simply came from the fact that we didn't have a full understanding of what was needed, and so, Mr. Sherrill, I thank the GAO for providing the information in a report that we requested to come to us. I also appreciate, Mr. Steinberg, your passionate defense of your position, of the Department of Labor's position. I don't see that as discouraging at all. I think you ought to defend the position, and I think in doing so you provided, at least for me, some more questions, along with some appreciation for decisions that were made. As has been already stated, Mr. Szymendera, the history lesson that we received was helpful, and to know for a fact that we, with our employees, rank very well with state workers, and I think in turn have taken many considerations related to the private sector as well. In lieu of the fact that those of us who would like to see a downsizing of the whole federal government in many ways, and yet not seeing that happening overnight, I think my distinguished colleague would agree as well. We have to take these considerations in for our employees. And so not knowing with any certainty that the legislation that we offered last term and passed here in the House, whether that will be offered again in the form that it was, at the very least we know that with information gained today, we can look to expand it, to add additional changes that might be necessary, might be perceived bipartisanly as very important to go forward with. And so I appreciate your testimony today. I appreciate the attention of the committee, the number of members that were here, and I think I can safely state that this will bear some benefit down the road. And so, seeing that there's no further business to come before the committee stands adjourned.